Okay, folks, we're going to get started in about 60 seconds. So if you could please take a seat, there's plenty of seats in the front, and we will start with our update of preparing for recovery, loan options, and forgiveness strategies. Well, folks, we're going to get started. It looks like we have a full house today. Just want to welcome you to our weekly update. This is April 30th, 2020. It's not quite as sunny today. It's a little overcast, but still going to be a great day. Again, we are broadcasting live from New Jersey, from our own home. So hopefully you won't hear too much background noises, garbage trucks, UPS, Amazon trucks, or dogs barking, but we'll try to keep that noise to far low as possible, but just want to welcome you back again. So this is our slide that tells you to make sure that although we are providing this information, this webinar, that you consult a professional advisor because our guidance does not constitute the provision of legal advice, tax advice, accounting services, investment advice, or professional consulting of any kind. So make sure that you speak to your professional advisor before you act upon the things that are being said. And just so you know, things are changing very rapidly. This wonderful PPP program is in the news, and therefore today's agenda is going to cover the introduction, which I'm giving you right now. We're going to do some updates. I know that you've been listening to the news about orange is the new black for those people who applied for the PPP loan and shouldn't have, and some other wonderful things. We're going to be talking about the updates and some loan forgiveness. Just keep in mind that as we're going through this, we're going to be pointing out to you where there is still some uncertainty. And folks, please don't believe everything that you read on the internet or Google or here, because there's a lot of conflicting information. Hopefully we'll provide you with some clear guidance, and I'm looking forward to today's update. This is the folks who are bringing it to you from Sachs. Myself, Todd Polinak, I'm a partner with the firm, as well as my partners Josh and Stephen are going to present on this update. You can see we all dress very professionally. I'm pretty sure that we're not dressed that way today. In fact, I'm not sure when's the last time we put on shoes. So I'm going to pass this on to Stephen. Steve, can you do the update?
Thank you, Todd. Good morning, everybody. I hope everyone, again, is staying safe and healthy and is doing as best as possible in this difficult situation. As Todd said, I'm going to start with some updates. For one, you probably have seen that there has been an additional $370 billion passed, call it CARES 2, CARES 3.5, it's gone by a number of different names, but we've seen some additional funding for both the PPP program, $370 billion, $60 billion of which was set aside for smaller institutions and smaller lenders, just making sure that the funds are dispersed as equivalent or equally as possible. And also $60 billion for the EIDL program. We're not covering the EIDL in much detail today. The EIDL, for those of you who do not recall, is the Economic Injury Disaster Loan Program. That's a traditional loan program. So there's an additional $60 billion in funding associated with that. And in specifics, there's $10 billion associated for the $10,000 advance program. So the EIDL program, as I just mentioned, is a traditional loan program, but there is a $10,000 advance / grant that basically would not be required to be repaid, except in certain circumstances where you get both the EIDL and the PPP. Banks began accepting applications on Monday of this week for the second round of funding. So the first round had $349 billion. This one for the PPP, $310. So the banks, as we said, have started accepting applications again. So if you haven't applied already, we strongly urge you, provided you meet the certification and other requirements, which, spoiler alert, SBA frequently asked question number 31 will be discussed in detail later, as it's received a lot of press in terms of eligibility. My partner Josh will discuss that in further detail, so you definitely want to stay tuned for that, because this information is, as we've said, hot off the press. So before we get to that, I'm going to cover some other items that we've seen. And one of the themes that we've discussed on really on all our webcasts in terms of best practices is staying up to date, staying current on the information. The SBA, via these interim final rules and different FAQs, have put out a lot of information to clarify certain points. And while there are still a number of open questions and items and considerations and whatnot, which we will cover at the end, there has been some clarification that's been put out. So there is an interim final rule which said that hedge funds and private equity firms, which, because they're primarily engaged in investment or speculation, these entities are ineligible to receive PPP. So that was a clarification that has been received. However, the portfolio companies are not necessarily excluded. They have to meet the regular affiliation and other eligibility rules, but portfolio companies themselves are actually eligible to apply, provided they meet the other requirements. Another component of the interim final rule, a separate interim final rule, actually impacted seasonal employers. And this was in respect to how they compute their maximum loan amount. Basically, Section 1102 of the CARES Act for seasonal employers dictated how seasonal employers were to calculate their loan amount, basically taking average monthly payroll costs for the 12-week period beginning February 15th, 2019, or electing to go from March 1st, 2019 to June 30th, 2019. Well, they've actually given seasonal employers another option here, in that they can choose any 12-week consecutive period between May 1st, 2019 and September 15th, 2019. So that is a mouthful. What the takeaway here would be, if you're a seasonal employer, there are certain different ways that you can calculate and compute your maximum loan amount. And also, if seasonal businesses were dormant or not fully operating on February 15th, 2020, if you recall, that was another eligibility requirement to have your actual business be active on February 15th, 2020. If the business was operational for any 8-week period between May 1st, 2019 and September 15th, 2019, they still qualify as well as other means to determine whether your business was fully operational. So seasonal employers got a break here in terms of eligibility requirements. Another important distinction, and one unfortunately that is still rife with uncertainty, is the aspect of full-time employees versus full-time equivalents. So for loan eligibility purposes, SBA FAQ number, is it number 36, specifically says that when you're counting employees in terms of eligibility, i.e. meeting the 500 employee threshold count, employees are full-time and part-time, so that if you have the example in the FAQ mentions if a borrower has 200 full-time employees and 50 part-time, the borrower has a total of 250 employees. So that's something to keep in mind. But by contrast, for purposes of loan forgiveness, the CARES Act uses the standard of full-time equivalent employees. So that's an important distinction to keep in mind. We're still looking for a definition exactly as to what full-time equivalents are, and we'll discuss that at the end later. But these are just kind of some new and other clarifications and eligibility requirements, which you may be interested in. But really the big one, which my partner Josh is going to discuss on the next slides, is this FAQ number 31 in terms of the good faith certification. So I'm going to take this opportunity and turn the presentation over to Josh now. Josh?
Hey, thanks, Steve. Good morning, everybody. So this is what happens when the government tries to do something good and they don't think it all the way through. You know, for those of you who have been so on top of this, there's been, as Steve and Todd both said, there's been a lot of bad press. You've all heard about Ruth's Chris and Shake Shack and even the Los Angeles Lakers, all receiving money that maybe they really shouldn't have and have since paid it back. So the SBA and its interim, final, I don't even know how many we're up to at this part, guidance on April 23rd, put out this FAQ 31, speaking specifically to certifications. So we're gonna do our best to go through it now, talk about what it says, and you know, in true, SBA guidance, they've given a little, just enough information for people to start making guesses as to what really means, but maybe not enough information to really make a good, heartfelt business decision. So the original certification that everybody who signed the application attested to was that the uncertainty of the current economic conditions makes necessary the loan request to support the ongoing operations. So for all of you who applied, that is the certification that you attested to. FAQ 31 further clarified and said borrowers must make above certification in good faith, taking into account one, their current business activity, and two, their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that is not significantly detrimental to the business. Now, if you read the FAQ, it totally speaks to public companies, who do have substantial, market value and access to capital markets. But it did leave to consideration all applicants. Certainly must consider these applications. And then they further clarified this again on April 28th, that it essentially applies to everybody, not just public companies, which was, like I said, the original thought on April 23rd. So in the news on April 28th, for those of you who have seen it, heard it, read it, Secretary Mnuchin indicated that loans of at least $2 million will be, I've seen reviewed, I've seen audited by the SBA. Important to note that the audit or review will not be conducted by the bank. We've been asked a lot of questions over the last 2 days, what the SBA will look at in terms of audit, when these audits will take place. We are not sure. We have not seen any information with respect to that. Again, this is purely because of the folks who applied who should not have. This is our government trying to save face and do the right thing. Important to note too that the SBA basically has said the lenders may rely on the borrower's certification They're not going to put the onus on the banks to do these audits or these reviews, whichever wording they ultimately decide to use. And ultimately, as we know, the forgiveness decision will be made by the SBA. They also did say that any borrower that applied for a PPP loan prior to April 23rd, which was the date of this FAQ, and repays the loan in full by May 7th, will be deemed by the SBA to have made the required certification in good faith. Also to note, based on what you've read, there's a lot of documentary out there with respect to penalties. Nothing with regards to amounts, but certain places you'll see civil penalties, certain places you'll see criminal penalties if there was, deemed to be blatant disregard, but nothing has been defined to this point. So what are we recommending? To our clients and prospects, and I think this is important. Each borrower should consider the impact of this newly issued clause and really document your reasons to support your PPP eligibility. We've listed some of the things below, but again, it could be well beyond some of the things which we've listed. So I just want to go through those for a minute or two. So the first point, and it was made in the FAQ about access to capital, right, outside the PPP. Available debt, whether you have a line of credit, which maybe you have not used, significant cash reserves in the business, and also to other capital resources, whether or not the company has the ability to sell equity, issue debt, whether or not businesses are owned by private equity who would have the ability to make a capital infusion. Again, this to us is what capital means, but again, there's been no definition as to how much capital, where it has to come from. It's very, very subjective and judgmental. Is your business open? I think Steve later is going to talk about what the AICPA is recommending to the government as to how forgiveness should be calculated. But is your business open? If it is, are you operating with a full staff or a reduced staff? Certainly a reduced staff would be indicative of trying to observe social distancing, but also based on sheer volume of activity. Did you have a decline in current sales? A lot of clients who we've spoken to are experiencing declines 40 to 50%, or cancellation of future orders, right? If you're a business that sells directly into the retail market, it's a very good possibility that right now you have no orders, and you're not collecting. Have your receivable collections decreased, and or have your customers requested more favorable payment terms? Again, just to go back to my last point about the retail market, for those of you who sell into the home goods, the TJ Maxx's of the world, where typically you would have payments of 30 days, not only are your future orders being canceled, but they're looking to stretch you from 30 days to 90 days. So certainly that would have a very big impact on your business. Supply chain issues, right? Are you having trouble even obtaining product if there's a market for it? A lot of clients still import from overseas. Some, specialty items right now, which maybe normally take 3 to 4 months, could take 6 months to get to you. And if you're fortunate enough to have the product here, there may be an inability to deliver the product to the client. And also too, it's very possible that there's a reduced access to the labor market. Folks who have been furloughed or unemployed, um, who knows, may not even be looking to come back to work during this time. So there are so many factors that could have an impact on your day-to-day operations, and another gauge too, because I know a lot of you folks have had discussions with your own customers and vendors, and many of them are also applying for this funding. So if we're applying for this funding, which is indicative of our current issues, it's very possible that they are also having these same issues. So these are some of the points. Like I said, there's definitely a lot more, but our recommendation is that you summarize all these points into a memo. So again, putting these things together, documenting your rationale as to why this PPP loan is very necessary to support your ongoing operations. And in addition to just putting the wording together, we suggest that you prepare a cash flow analysis, looking at 30 days from now, 60 days from now, 90 days from now, really projecting forward what cash flow is going to look like. And you want to adjust that cash flow to account for potential loss of income, the slowdown of receivables we talked about, lack of currently available credit facilities. Even if you have a line of credit that's available to you, it's possible that the bank may not allow you to draw down the full amount. And also, too, talking about access to credit, if you were to go to a bank right now and apply for an increase in your line of credit, knowing that you may need it, you may have a lot of difficulty with that, given that a lot of the banks are so focused on or I shouldn't say aren't so focused, are 100% focused on fulfilling the applications for customers and non-customers. That's really taken up 110% of their time. Also factoring in, again, potential employee layoffs or furloughs, any debt repayments, projected expenses, and other cash disbursement commitments, would be one example to demonstrate that the PPP loan is needed to be able to support ongoing operations. If you go back to the original spirit to what this program was, it was maintenance. It was to keep people employed, maintain whatever kind of operations you can during this time, so that when we get out of this, you're able to fire back on all cylinders. And the last point I want to make with respect to this too, is that it's one thing to put all the documentation together, but ultimately I think you want to document that this plan, the cash flow, has been approved, and again, depending on how the company is structured by the owner, if you have a board of directors, you want them really to vote and sign off that this was a company decision, and it was made by the top elected officials of management, and again, the board as well. So documentation is key. We're having a tremendous amount of conversations with as you can imagine, surrounding this. I think fact pattern is still important. There has not been any information that's come out with respect to what's involved in a review or an audit by the SBA, but certainly have all your ducks in a row, and we'll come back to you with more information as it becomes available. So since all the effort has been thrusted towards FAQ 31 and the second round of applications, there hasn't been anything ground, earth-shattering with respect to loan forgiveness. But I'm going to toss it to Todd now, who's going to take you through again Some of the areas where we still are unsure, but also be able to give you a little commentary as well. So Todd, I'm gonna throw it your way.
Thank you, Josh. So the topic of forgiveness, this is really the hot topic. I know that folks are now saying that the PPP program should be termed the Accountants and Attorneys Full Employment Act. And yeah, I get that because things keep on changing almost every day. So we felt that it was important to at least give you a recap of how forgiveness is calculated based upon what we know today. So this is the recap, and then we're going to talk about what still has not been really told us by the SBA. Caveat, the SBA still needs to come out with additional guidance. So stay tuned to these weekly updates and our e-blasts as to what that may look like. So I'm going to go through 4 steps. Step 1, you're going to start with the eligible costs that are forgivable and spent in the 8-week period. Payroll costs must be at least 75% of the forgivable loan amount, and then certain non-payroll costs are capped at 25% of the forgivable loan amount, which is interest on mortgage obligations, rent, and utilities, and some other non-payroll costs. And folks, just want to make a point here. We're giving you a very high level of this recap. You probably need to go back into some of our former slides and presentations if you want the full gamut of what this entails. So that's step 1. Step 2, you apply this lovely formula that considers first your workforce reduction, A divided by B, A being the average number of FTE employees during the 8-week period, beginning with the date of the loan origination. B, the average number of the FTE employees from February 15th, 2019 through June 30th, 2019, or your option, January 1st, 2020 through February 29th, 2020, and you apply that lovely formula to the eligible amount that could be forgiven. And then step 3, you look at the decrease amount by certain employees whose wages were reduced during the 8-week period by an excess of 25% compared with the most recent full quarter during which the employee was employed prior to the commencement of the period. And keep in mind the $100,000 limit. And then step 4, for the period from February 15th, 2020 through April 26, 2020, where there was a decrease in the FTE employees or wages, and you restore the FTE employee count or wages by June 30th, 2020 to the pre-February 15th, 2020 status, you get some type of reprieval. Again, you notice the caveat. We put it on both slides to make a point. The SBA still needs to come out with additional guidance. All right, here's some things we still do not know. Following questions still are unclear and need further guidance from the SBA. Are the costs for the 8-week period to be determined on a cash basis or an accrual basis? Number 2, at least 75% of the loan proceeds shall be used for payroll costs. What happens if I spend less? 3, should full year bonuses or year-end profit sharing contributions be included in the forgiveness calculation? 4, does rent cover only costs for facilities, or do equipment rentals count as rent for forgiveness purposes? 5, how is full-time equivalent calculated? 6, how are non-COVID-19 reductions in workforce and or salary treated for purposes of the loan forgiveness reduction? 7, Will the formula for salary reduction be prorated, adjusted? 8, do exceptions for headcount and or salary reduction allowed for a replacement of the terminated worker? And still unclear, needed further guidance. Number 9, what types of transportation costs qualify as utility costs? Number 10, for employees rehired by June 30th, is there a time period for which they need to be employed in order to count towards the headcount / salary restoration? 11, will the expenses associated with the forgiven funds give rise to a tax deduction? And 12, will the forgiven funds be tax exempt for state tax purposes, wherever state you may be in? So these are still open questions, and we love to hear from you if you have the answer. We know a lot of people think they have the answer because we've read their comments in other internet and websites, but we'd love to know what you're thinking too. But I want to turn it over to my friend Stephen, because I know that the AICPA is making certain recommendations to the government. It's great to know that our fees are paying off to the AICPA. So Stephen, can you tell us a little bit about what the AICPA is recommending to the government that addresses quite a few of these questions? Stephen?
Sure. Thank you, Todd. As I had alluded to earlier, staying current on these rules and information that's put out is extremely important. In light of that, the AICPA just yesterday issued a series of recommendations to the SBA specifically related to the PPP. And in that release, the AICPA urged that the 8-week covered period, which is basically you have 8 weeks to spend the proceeds. As of now, it's as of the date you receive the proceeds. They are saying and requesting that the PPP 8-week covered period should align with your payroll period, so the beginning of a pay period, as opposed to the date the loans are received. So that would be potentially beneficial to borrowers. They're also saying the 8-week period should commence once the stay-at-home restrictions are lifted, not when the loan proceeds are received. So there are businesses that are in a difficult spot in that they are closed, but still applied for these loans because there was only a finite number of proceeds available. Now they have them, but they're not open. So here's a potential resolution to that. They've also requested a simplified calculation for full-time equivalents using a simple wage-based proxy when hours are worked and not tracked by the employer. And they're saying the payroll reduction, this instance where your forgiveness is impacted by a 25% reduction in salary. As of now, you're comparing an 8-week period to a prior full quarter, which in essence, a prior full quarter would be either 12 weeks or 13 weeks, depending upon how the calendar lies. So just based upon sheer mathematics, when you're looking at 8 weeks versus 12 or 13 weeks, just by the nature of the math, it's going to be a reduction in salary. So they're hoping that there's ways that they can kind of make this so it just works out numerically or mathematically so that borrowers aren't automatically impacted by this. And as Todd had mentioned, this only would be for those salaries or on an annualized basis of less than 100,000. So we can see, and we'll see if the SBA, this was also written to Treasury Secretary Mnuchin and the SBA administrator. So we'll see if they're listening. We'll see if they take this into account. As we said before, there is constantly new information. We are staying on top of it, but suggest that you do so already. Only just, again, you may not want to believe everything you read. And before I turn it back over, there is another point I'd like to clarify. I understand that there may have been an audio issue. This relates specifically to the loan eligibility versus loan forgiveness from an employee headcount / full-time equivalent definition. So the CARES Act says that for purposes of loan eligibility, you count individuals employed on a full-time, part-time, or other basis. So if you recall, we mentioned that generally borrowers are limited based upon headcount. There are other means to get there, but assuming you're on the headcount threshold, or even if you're not actually, but just in general, you account for that by counting all of your employees. So the FAQ specifically references if a borrower has 200 full-time employees and 50 part-time employees, the borrower has a total of 250 employees. Loan forgiveness, however, as was referenced on the earlier slide in terms of a open question, is on a full-time equivalent employee perspective. So those numbers could and likely would be different if you have part-time or other basis employees. So that's an important distinction. Hopefully we get some clarification on the full-time equivalent item, because that is impacting loan forgiveness. But at least we have some clarification in terms of how the eligibility is determined. So with that, I'm going to turn it back over, and we'll just look to wrap this up.
Josh, do you have any comments before we wrap it up?
Only really to say, you know, going back to what Steve was saying before with respect to the AICPA, those are recommendations that the AICPA is making to the SBA. Nothing has been changed or approved with respect to those recommendations yet. So until we hear anything further, I think it's important for people just to continue forward with what they're doing. We're doing the best we can to stay on top of it and put information out. So hopefully, in addition to the webinars, everybody's receiving all of our emails. You know, but other than that, there have been, you know, a lot of questions that have, you know, come through. You know, please, you know, continue sending your questions. But Todd, that's all I had to say.
Okay. So with that, we're going to go to the last slide. This is the important slide. So if you have any additional questions, email covid19@sacsllp.com. And by the way, if you're a client and you have a connection with one of the partners, you can reach out to them directly. You don't have to go through the covid19@sacsllp. Just want to make that point. And also visit our COVID-19 Resource Center that's found at our website. You'll also see that we are offering a new service specifically related to the PPP program and tracking the forgiveness and giving some advice there. So look at that. And our next webinar is scheduled for next Thursday at 10 a.m. We'll be updating you. I'm sure that by next Thursday, we'll have some new information. And if anything comes out that's earth-shattering, obviously we will move up that webinar. But for now, it's every Thursday at 10 a.m. Wish you all a wonderful day, this wonderful Thursday. Stay safe and healthy and keep hope alive. Take care, folks.